Okay, so we all know it has been a busy year with regulations here, there, and everywhere, and all sorts of fascinating cases affecting agriculture and the environment. And so we have John Dillard and our very own Paul Goringer here to tell us what we should be watching out for in the coming year.
Thank you. Good morning, everyone. It's an honor to be out here. We're going to have a little bit different format here. I've been told not to open up a talk with an apology, so I'm not apologizing, but I'm going to cover a wide array of topics, and I recognize that there are going to be people in here that are going to have more kind of specialized knowledge about things, so we're all here to learn together. So if you have something to add, don't be shy. Speak up if you have questions. Go ahead and raise them. No need to wait till the end. So we're going to do kind of a lightning round of different regulatory issues coming up, and they're all over the map. So it should be something for everybody. First one, WOTUS, Waters of the United States. Show of hands if you have not heard of this. Okay. Well, there we go. Kim, I'll speak to you directly. No. So I write a column for Farm Journal, and I found that this issue, the waters of the United States, kind of setting the jurisdictional boundaries of the what the EPA and the Army Corps of Engineers have over in particular wetlands or other waterways on property was a red meat topic that really resonated with farmers and really got people riled up. And then the lawyers got involved, and this was a rule that was first being talked about in 2014. It was finalized in 2015, and it has just gotten to be something that's gotten is in so many different lawsuits and in so many different postures depending on where you're located that it kind of fell off of my memory. So I took the opportunity of having this. I made Paul assign me Waters of the United States so that I could re-engage on it and figure out what the hell is going on. Kind of the impetus for it, for the people that haven't been following it, kind of the origins of it, we had a 4-1-4 decision in the Supreme Court back in 2006 that addressed or attempted to address what's kind of the outer limits of the Army Corps of Engineers jurisdiction over wetlands that are adjacent to navigable waters or tributaries to navigable waters. Now I mentioned it's a 4-1-4 decision, so there wasn't a definitive decision, and there was really two interpretations that have been considered, and it depends on if you want to have jurisdiction over wetlands, you go with Justice Kennedy's concurrence in the case. That kind of split the baby, and if you want to keep the federal government kind of out of your affairs, the general preference is for Justice Scalia's interpretation or his concurrence in the case. Well, the federal government, when deciding whether or not when they get an opportunity to decide what kind of jurisdiction they want to have. If you can believe it, the federal government typically errs on the side of giving the federal government more power, and that's what happened during the Obama administration. The Army Corps of Engineers and EPA embraced the idea that when looking at adjacent wetlands, the federal government would have jurisdiction over it if there was a significant nexus to a navigable water or a tributary to a navigable water. And so part of where they got kind of out on the outer edge of the envelope was, building into the interpretation biological life cycle. So if at some point tadpoles spend time in a puddle and then they hop over to a tributary, that puddle that's otherwise isolated is considered jurisdictional. Now, like I said, that's on the outer edge, but that was certainly some of the arguments that were made against it. The rule went into effect, or was finalized in 2015. Immediately there was a bevy of lawsuits. And that's where I kind of dropped off, but have now jumped back on and trying to figure out what's going on. So the Trump administration, President Trump, actually made this kind of a red meat campaign issue across the Midwest, in particular in farm country. And so one of his campaign promises was, first day in office, we're going to get rid of WOTUS. Came pretty close to that. Pretty shortly after the president came into office, they issued a rule that would delay implementation of the 2015 WOTUS rule by 2 years. And the idea was that the administration would come up with a replacement more to their liking. And so, like I said, all the lawyers got involved. So there's been several major decisions on WOTUS, and kind of whether it applies to you depends on where you live. Probably the bent of whatever Attorney General was in office in 2015, that applies to you. So one of the most recent, or some of the more recent decisions, the Supreme Court, kind of one of the main issues coming out the gate was whether the WOTUS rule could be challenged in the district court or the Court of Appeals. So under the Clean Water Act, most decisions are, and this is where somebody with more expertise, I know there's a lot of Chesapeake Bay people here, you can raise your hand and correct me, but it's my understanding that effluent limitations are challenged at the Court of Appeals level, and most other things are challenged at the district court. I'm waiting for a nod or a disagreement. Okay, we'll go with that. And so there was a disagreement over whether WOTUS was something that could be challenged at the circuit court level or at the district court level. And so there was a big group that appealed, I think, immediately to the Sixth Circuit and the Eighth Circuit, one of those two. And that eventually made its way to the Supreme Court, kind of the fight of, does this belong at the Court of Appeals or does it belong at the district court? Nothing about the actual merits of the rulemaking, and it eventually made its way to the Supreme Court, and the Supreme Court ruled in January that it's something that should be challenged at the district court level. While the rule had been stayed by the Court of Appeals, that was no longer the case, as it had to be remanded down to a district court. There was another challenge that was decided more recently. It was a challenge on EPA and the Corps' authority to delay the rule for 2 years. The rulemaking that was put out without notice or comment, or without an opportunity for public comment. So there was an Administrative Procedure Act challenge to it, and recently the district court for South Carolina ruled that was improper, and so now the WOTUS rule is in place for 26 states. There are 23 or 24 states, the other states, where the rule is not in place, where the rule has been stayed, and that goes back to, I said, the applicability of this rule all depends on the bent of your Attorney General in 2015. So there were 11 states that joined one suit, kind of led by Georgia. There were 13 states that joined a lawsuit led by the Attorney General of North Dakota. In those states, the rule is still stayed. And we have seen the American Bar Association website has their environmental section has a good rundown on kind of all of these events, and we are seeing instances where EPA and the Corps of Engineers, even under this administration, is moving forward with enforcement actions based on the Obama era, the 2015 WOTUS rule. This isn't a court case, but we have had the Trump administration, the EPA has kind of submitted its plan to the White House. The Office of OIRA is kind of reviewing the EPA's and Corps' plan to replace WOTUS. It hasn't been made public, but we think it's going to kind of embrace the Scalia view of this, that there needs to be a relatively permanent standing body of water that's continuously flowing, and any wetlands that fall under the jurisdiction need to have a surface water connection. So, any questions on WOTUS? We're moving on. All right, just there, that's a map that kind of in red, that shows you where WOTUS is in effect. So it really depends, like I said, on what was the bent of your Attorney General in 2015. So next one, the North Carolina hog lawsuits. I probably not as big of a national topic as the WOTUS issue, but certainly something that's given a lot of attention. I know there's a lot of CAFOs here in Maryland, as there are in a lot of places, and always run into issues with neighbors and kind of the argument of the kind of not in my backyard type thing. So if you're not familiar, there's been a group of about plaintiffs' attorneys that have recruited about 500 plaintiffs in eastern North Carolina, which is where a lot of these concentrated the hog confinements are really built up around. And they are suing Murphy Brown, which is the kind of live grow-out arm of Smithfield Foods. The lawsuit is kind of your standard nuisance, negligence, the living near the barns, living near where they're applying manure. The allegations are it's affecting the quiet enjoyment of property. It's attracting flies. Can't use my the argument is I can't use my property kind of in the way that I intended. There's also a social and environmental justice aspect to this. It's not so much in the pleadings, but certainly the PR around it, alleging that these facilities were located in communities that are predominantly black or rural communities where they're predominantly black. The idea that's kind of oppressive to the neighbors. Because there are so many different operations and nuisance cases don't lend themselves to being conducted in a class action because you have so many different types of damages. The court has ordered the parties to split up the 500 plaintiffs. It's into 26 different cases. And when this started, the judge said, we're going to hear one case a month until this is all done, and then we can appeal everything. Or then we'll handle any of the appeals that you have on a lot of preliminary matters. So far, there have been 3 trials. The first one resulted in a $50 million verdict. Under North Carolina's law to limit punitive damages, it was cut back to $3 million. The second one it was considered the trial most favorable to Smithfield and Murphy Brown. The jury issued a $25 million verdict. That got cut back to $630,000. You see here kind of a learning curve by the time you get to the third trial. How North Carolina's punitive damage cap works. You can either max out at 250 or 3 times actual damages. And so the first two juries issued kind of fairly low actual damages findings. Somewhere along the way, the plaintiff's attorneys figured out that they weren't actually, nobody is actually going to get a lot of money. And then in the third lawsuit, you started seeing some astronomical actual damage figures being issued by the jury. There have been major issues with this litigation that have not been resolved, and if it does get to an appeal, some issues that could be considered. Like every state, North Carolina has a Right to Farm Act. We advise a lot of clients in kind of these matters, and I will say from a farmer's perspective, on paper, North Carolina has a very good Right to Farm Act. One of the provisions that it has in place is that there's typically kind of a time window for plaintiffs to sue a farming operation or a new farming operation, and North Carolina's is written such that a farming operation doesn't become new if you change production types or change size. So if you go from a crop farm to hogs, or if you go from having 10 hogs to 5,000, that's not a triggering event. The way that the federal judge in the Eastern District has interpreted that, he held that in about 2 paragraphs addressed all of North Carolina's right to farm law, and held that these hog farms did not predate the residents that lived around them, and thus it didn't apply here. Another major issue in this case, the jurors were not allowed to actually visit the barns. The defense has not been allowed to present any expert witnesses. And I happen to have a personal friend that's participating in this case, and one of, I think, his frustrations, they actually have they've been able to bring in a model of a pig, not like a kind of pig mannequin, slathered with manure, and bring that into the courtroom, and somehow that's relevant, but they've not been able to actually go to the farm sites. And another issue here, and I think this was done for optics, the plaintiff's attorneys didn't sue the farmers. So that's able to kind of, instead of pitting neighbor against neighbor, you're really pitting the neighbor of the hog farm against this big multinational corporate entity. But you have missing plaintiffs. That's another appealable issue. And one thing that's been frustrating for groups like Farm Bureau, for the Pork Producers Council, any of these groups that are kind of involved in a case had been until recently subject to a gag order, and so they were not able to properly advocate for their members that were being targeted in this. Kind of where we are right now, the parties are currently in mediation. This could result in a settlement that I'm not going to speculate on what it would look like, but probably some things at play. Certainly there would be money changing hands. There may be some buyouts of farm facilities or some adoption of new practices. That's hard to tell. It's hard to tell if they're going to get to a settlement. The judge in the case has decided to sit out trials number 5 and 6, kind of in the order. But like I said, it's all kind of on pause right now. Unfortunately, from the farmers' perspective, even though they weren't named in the lawsuit, The farmers that have been running the operation subject to the ones where there have been verdicts and there has been liability, they have lost their contract with Murphy Brown. The idea being, if the facility has been deemed a nuisance or deemed negligent, it would be kind of continuing that if they kept it up. If mediation doesn't work, they will be allowed to pursue kind of the interlocutory appeals. So, any questions on the hog lawsuits? All right. Next one, gene editing. Oh, yes.
Yes, I just wanted to find out if, out of the 500 plaintiffs, if there were any farmers who were plaintiffs in that case.
I assume just if you find 500 random people, statistics are you're going to have somebody that has some type of farming operation. But it's my understanding that if there is anybody that's actually would be the short answer is I don't know, but I don't think so. I'm at least making that statement in terms of I'm not aware of any other fellow hog farmers or fellow kind of major crop producing farmers involved in this on the plaintiff side.
Hi. Just to clarify, if mediation is successful, then that therefore means that there will not be appeals, so there would be no appeals to, or this may set a precedence for North Carolina's right to farm law as being ineffective in a case such as this, correct?
That is well, I think that's correct. I mean, obviously, if mediation is successful, there won't be appeals. The North Carolina legislature kind of jumped into action after the first verdict was issued, and they amended it. They amended the Right to Farm Act to kind of target this type of issue and to clarify and limit the scope of parties that could appeal. And I think they also reduced kind of the financial incentive. I think the maximum you could get in punitives is something like $100 grand. But they definitely, the legislature built it kind of around the idea of preventing something like these types of lawsuits from happening in the future. Governor Cooper vetoed it, and the legislature, a supermajority, overrode the governor's veto. So I don't expect anything like this to happen quite the same way in the future in North Carolina.
Okay, I'm coming.
Have you compared North Carolina's right to farm law to Maryland's? I kind of already know the answer, but can you? If you have?
That's a darn good question, considering I'm standing in Maryland right now and speaking to a Maryland audience, and I haven't, but I think Paul can address that.
Figure out how to turn my microphone on. So the difference would be mainly Maryland. You're going to go to mediation first if any right to farm dispute comes up, which is a major difference between North Carolina's and Maryland's. The other difference is going to be we still have, well, not difference, we still have the 1 year statutory provision that you need to be in operation for 1 year. I think looking at it, our punitive damages law is different from there. You have to show actual malice to be able to get punitive damages. So looking at our right to farm law is a lot different in how it's going to apply in these cases than in North Carolina. At least the old version in North Carolina.
Okay, so let's move forward with the rest of the presentation, and John will be here to answer all questions later on.
Certainly. All right, we're gonna. I realize I've taken up a good bit of time on these two topics, and that's that's great because I know I cringed. My background or college was in like animal science and ag econ, and then I figured out that like organic chemistry nearly killed me. So I had like kind of shakes when I saw the diagram up there, and I figured out from math I'm best at just counting to the 10th of the hour. So gene editing, really quick, biotechnology in general the federal government has not had a very efficient or streamlined approach to regulating biotechnology, and that, while certainly frustrating to innovators, it wasn't as big of a problem because it was so expensive to come up with different traits, and it was such a slow process, and there was such a big payoff if you did have one go through, like the Roundup Ready trait or anything like that. But the kind of advent or rapid commercialization of gene editing technology, CRISPR, means we have a lot more traits coming out, or the potential for a lot more traits coming out, and the government, the federal system is a huge bottleneck right now. So most traits that come through every trait that comes through that's going to be used for food has to go through at least USDA's APHIS to determine if it's a plant pest. It has to go through FDA to determine that it's safe to go in the food supply. If it has any type of insecticidal properties or anything that would fall under FIFRA if it was a chemical, that applies to the trait. That's really slowed down and kind of ground the gears on getting new traits through. In 2017, like January of 2017, the Obama administration put together kind of a coordinated framework for getting this through. It was hailed by some as progress by just coming up with a coordinated framework, but it also was still kind of incorporated a lot of the procedures that were or would have kind of codified a lot of the things that were already slowing stuff down. So the Trump administration, like everything that the Obama administration put out in January 2017, said, no, we're going to hit pause on that. We're going to roll that back. And so the agencies within the current administration have taken a fresh look at this idea and haven't completely scrapped everything that was proposed under the Obama plan, but the agencies recognize that kind of now is the time that they need to be acting on this. So we have a few updates. Actually, last week or the week before last, FDA released kind of a framework, or it's more of a high-level review of how the agency wants a regulatory framework to look. And they are working and coordinating with USDA and with EPA to make sure that they have something that can accommodate this new technology. I don't have a ton of details on that. In terms of the USDA side, I have had the fortune of sitting down with a couple of folks very close to the process. They haven't released a proposed rulemaking, but there's going to be a dramatic change in the way that APHIS takes a look or evaluates new traits that are commercialized strictly from the Plant Protection Act. And so the traditional approach has been to concentrate on how a particular plant got its genes or how a particular trait got there. Transgenic modification. That's what's everybody's, until 5 years ago thought of as genetic modification. Everybody's been focusing on that, so anything that was produced through transgenic modification was subject to scrutiny under APHIS. APHIS has kind of taken a step back and said, hey, the statute that we're operating under says we look out for plant pests. So if we're presented with a new plant, that's how we need to be looking at it, not the method that a particular trait got into a plant. So we're going to see a fairly streamlined approach coming from APHIS. They are taking the stance, which is consistent with Secretary Perdue's stance in general to dealing with genetic engineering. Any trait that could have been developed through traditional breeding techniques is not going to be regulated under the Plant Protection Act unless it somehow poses a plant pest hazard. So the agency is interpreting anything gene edited either through deletion or rearranging genes. Like I said, I don't know how it works. Anything produced through gene editing is going to be considered something that could be produced through traditional plant breeding techniques. And yeah, that's it on that. Any questions on gene editing? It's kind of a pretty light update. All right. Another quick one, the National Bioengineered Food Disclosure Standard. We're expecting to get that next month. In 2016, kind of in response to some states, particularly Vermont, having a statewide GMO labeling law, Congress stepped in and preempted any state labeling law. In exchange for that, they said that any product that is deemed bioengineered needs to bear a disclosure, either in words, these fun symbols right here, or some type of QR code that you could scan or and look at and see, okay, was this produced through genetic or bioengineering? That's the term. And the law was written. If Congress really thought there was an issue with people not knowing about genetic engineering used in their food, they wouldn't have wrote it like this. This was a law that was passed to make this issue go away. And I'll give an example. For something to be labeled under this, it has to contain bioengineered genetic material. And focus on genetic material. I'll talk about that in a second. So Congress defined bioengineered as meaning it contains genetic material that's been modified through in vitro recombinant DNA techniques, and it's not something that could have happened in nature. So that automatically covers kind of what we 5 years ago thought of as genetic modification, like the Roundup Ready traits or the BT corn, something where you take DNA or a gene from one animal or plant or bacteria and put it into another organism. Congress also entrusted the Ag Marketing Service to put together a rulemaking. They asked that it be finalized within 2 years. We're past that, but the government's like, what are you going to do? We'll get it to you. And there are some big exceptions to this. Alcoholic beverages, which are labeled, labeling is typically under the Tax and Trade Bureau, except for wine coolers and spritzers. So remember that. And then most meat products. So if you have a meat-based product, it's not going. If meat is either the most predominant, or if it's a soup where broth is the most predominant and then meat's second most predominant, it's not going to be labeled. But it's not a complete exemption for FSIS regulated products. So in May May of this year, AMS proposed a rule for their labeling. That's where they produce the nice little symbols and stuff. But they left, they said, hey, we're still trying to figure out a few big questions. Number one, what all falls under bioengineered? And so the question, the big question that's going to be, needs to be solved by the time it's final is a trait or a product that's produced using CRISPR technology where it's gene edited, where it could technically occur in nature because you aren't pulling genes from one animal to another. Is that going to be covered? They haven't addressed that yet. That's something that's going to be put together in the final rule. The second issue, and this is the one where I said if Congress really thought there was an issue, they would have done it differently. And, you know, they said you've got to label if there's bioengineered genetic material. In this case, the question that they have is should highly processed foods that contain little or no, basically a de minimis amount of DNA, be considered bioengineered? And so the things that are going to fall under that are going to be like your soybean oil, your high fructose corn syrup. And they didn't pull that out of thin air. There are some countries that don't require labeling on products like that. For example, Australia and New Zealand, highly processed products that don't contain DNA of genetically engineered products. It's not subject to labeling. But if you go to the EU, their approach is this is more about the raising technique, so we need that disclosed. That's not been addressed yet. The agency or AMS has kind of come up with their final plan. They've submitted it to the Office of Management and Budget for final review, and we're expected to get it this month or next month. The other thing, I think their plan is to, or I don't even think it, their plan is to have it go into effect concurrently with the new Nutrition Facts panel on January 1, 2020. So, any questions? All right. I'm going to turn it over to Paul.
And I'm probably not going to pay attention to you. So we're going to go through mine. I'm going to talk about air emissions, some environmental reviews, CAFOs, permits, and we're going to talk about Dicamba yet again. If you were here last year, we kind of talked about that, and I probably need to move that slightly closer to me. Those are all the topics I'm not going to talk about today, so we can just skip all of those and continue on. So let's talk a little bit about dicamba drift. Dicamba drift issues around the country have gotten a lot better over the past year. We went from about over 2,000 cases to 600 cases this year. This has not been updated, the one on the right. I think that's on your right. This year, that was from July, so I haven't seen what the final numbers have turned out to be yet. That's done by the University of Minnesota or Missouri through one of their weed specialists there. He puts those numbers together each year. So EPA announced new registration requirements last week. It's going to be registered for over-the-top use for 2 years, and this is just the new products that have come out. Some of the things that are going to continue to be in place and changes that are going to come in are it's only going to be certified applicators, again, can only use this product, prohibits over-the-top applications after certain time periods. There are times of day when you cannot apply this stuff. Other protections there for endangered species, better training processes this year, enhanced tank cleanouts. And going back to what Lindsay said earlier, there's more labeling information. So if anybody needs a novel to read that's really tiny print, you can go find this online, and it'll probably put you to sleep in about 5 minutes. The other important thing with this is we have all these ongoing class action lawsuits. These were all consolidated into one class action lawsuit earlier this year in the Eastern District of Missouri in St. Louis, i.e. the former corporate headquarters of a company that used to be called Monsanto that is now probably going to be called Bayer at some point since they have been bought out. The first case will go to trial early or about this time next year in October. And this is one farmer claiming damages on his peach crop, specifically for years sort of prior to when all this sort of happened with dicamba becoming an issue. Let's talk about hazardous waste emissions. These slides may look familiar. They were used last year. I just copied and pasted them in, so I'm not going to talk about them that much. But the main issue is EPA was sued on creating this exemption. They said in 2010, hey, we're going to create some sort of new process for this. Then they really never did anything till about 2015 when they were forced to, and the Court of Appeals came in and said, no, this isn't going to work. You can't create an exemption. And as Jenny, John, I'm trying to think who all else was at these workshops learned, how easy was it to help producers try to figure out what their air emissions were going to be from some of these facilities? It was not an easy process. Congress did act. They passed what is known as the Farm Act in the Bipartisan Budget Act of 2018. They exempted all animal operations from CERCLA reporting. Then last week, EPA announced that under another law that is focused in on local communities, that they were just going to say there's no reporting requirement under that. There's an issue within CERCLA to where if you're not required to report under that law, you don't have to report under the other law. So this was just to clarify this. So hopefully animal waste no longer has to be reported currently. Gary's CAFO was upheld. Good job, Gary. I was supposed to put your picture there, and apparently I forgot to do that. So, but the challenge was focused in on wanted more manure analyzing than was going on. They wanted to see more of this done. The court looked at it and said, this is a zero discharge permit. Everything it's done in it is perfectly fine. It was okay to use BMPs in that as well. And let's talk about CAFOs in court. So talking about this, how many people have heard of Food and Water Watch versus USDA, the challenge for the Caroline County? I'm hoping Holly raises her hand and a few other people. So this is where a NEPA challenge was brought, not against the farmer, but against Farm Service Agency for not doing a proper review when they granted a loan guarantee for a farmer. It is currently in court in the D.C. Circuit. Recently, they ruled on procedural issues. The claims are not moot, and they have standing to bring this case. Basically, FSA was arguing in trying to get this kicked out that they really can't do anything to this farm since it's been built. The farm's in operation. We should just leave it alone. The court disagreed and said they could always go back and revise the NEPA review. There were prior court rulings in other states saying, yes, this is a possibility with FSA when they do not do a proper analysis. They also found that they had standing. There were demonstrated people who are members of this organization who could claim an injury, who live near the farm. So it's pretty easy to find standing for the court in reading the opinion. The case is moving forward. One of the issues in this case is the claim is FSA and USDA should be doing air admissions reviews in these processes as well, so it's not clear how the court's going to turn on that issue as well. They haven't yet ruled on the fact if the NEPA analysis was good or not. And then MDE versus Bishop, where Gary lost in court. I get to throw you under the bus for losing. I'm glad you sat on the front row so I could see you. It's very hard to see anything with that light right there. So this is an administrative decision that was involving a challenge to Worcester County Poultry Farms Nutrient Management Plan. It all challenged around the ideas, was temporary storage in the house and temporary building of composters compliant with MDE regulations and what NRCS wanted to see out of this. The administrative law judges basically agreed with the environmental groups that temporary storage in the house is not enough, and the temporary composters did not meet the definition of what was required with NRCS. They did reject the claims that you guys should be taking in air admissions, so you don't have to do that yet, but that was just because you don't have a law that tells you to do that yet. So that is one thing that has been popping up over and over again in some of these cases as well. And any questions? John's going to answer all the questions now.
Either or. There's some discussion on how can we phrase it? Milk from almonds, and with Thanksgiving coming up, we have turkey made out of tofu. Do you know about what's happening on the legal side on that?
On that, actually, I'll stand up here. On that, it's something where there is a standard of identity in the Code of Federal Regulations that defines milk, and it says it's from basically I can't remember the exact terminology, but it's either from a cow or a goat, or mammal. It's a mammal that lactates, and so that's been something that has certainly irked the folks in the dairy industry, especially as kind of these alternative products crop up. Especially, they get irked when it's in the dairy aisle right beside their milk. But it has been something that FDA has kind of allowed to go forward despite the standard of identity. I know Commissioner Gottlieb has announced that FDA is going to be reevaluating that to determine if they do need to make some changes in terms of how they enforce labeling with kind of these alternative milks. But they haven't, beyond the announcement that they're going to be evaluating it, there's not been any substantive change. Yeah.
Okay, well, please join me in thanking John and Paul for those updates.